Who's ready for part 2? This time I will be acting as the prosecutor in the case against Tiger Woods. Please like, subscribe, and share. Now, in my previous video, I played the part of the legal defense for Tiger Woods. In this video, I'm going to be going over if I was a prosecutor on this case, how would I go about handling this case, and what penalties I would seek out against him if I was a prosecutor on the case. And disclaimer, no, this is not legal advice. Now, before I dive into the details of this case and what I would do if I was a prosecutor on this case, I'm going to give you a little bit of background on what happened. Also, you can watch my previous video for more detail on the background. I'll attach it below in the comments and put it at the end of the video. The role I play is defense attorney if I was on this case. But here's a little bit of the background.
WPBF 25 News starts with breaking news.
And we are staying on top of that breaking news. A subpoena that Tiger Woods is fighting for his prescription drug records. Our news teams just got our hands on those new court documents. Within the past hour, Woods is facing DUI charges following a crash on Jupiter Island on March 27th. Thanks so much for staying with us at 9:30. I'm Nathalie Pozo.
And I'm Stephen Graves. In that newly filed motion, Woods' attorneys argue he has a right to privacy when it comes to his prescription records. They also ask for a hearing to determine if prosecutors should be allowed to obtain Woods' records at Lewis Pharmacy on Palm Beach. As we told you a few weeks ago, prosecutors were seeking Woods' records from much of this year. The golf legend is officially charged with DUI and refusing to submit a blood or urine test after that crash. While he's charged with DUI, authorities say he did blow a 000 on a breathalyzer, and they believe he was under the influence of something other than alcohol. Woods pleaded not guilty and has waived his arraignment. He did say he is, quote, stepping away to seek inpatient treatment in the meantime, but he did not specify for what condition.
Make sure you guys like, subscribe, and share if you made it so far. So let's dive into the legal statute very briefly before I dive into how I would prosecute this case. Now, as you can see, here is the source I am citing, and I'm going to put up the specifics of the law and how I would apply it to this specific case.
Here's the discovery packet you asked for, along with the updated statements.
Thank you, Julia. Mind if I take a look? Go ahead.
If you need anything else, just let me know.
Will do. Appreciate the quick turnaround.
Now, it's up to me as a prosecutor to apply the facts of the case to the law. Now, my primary objective here as the prosecutor is to prove each statutory limit to the offense of the law that I just showcased to you. I had mentioned to you in the previous video, if I was the defense attorney, that I would be trying tooth and nail to keep any former crimes and his previous car accident in 2017 of similar circumstances out of this case. As the prosecutor, you would definitely want to bring this in. This is going to help rail your case home. You would definitely want to bring up previous incidents that are very similar in order to show a pattern and to show that he would continue to do this if allowed to go unchecked. Now, as I said, bringing up his past infractions with the law, particularly when it concerns to him and driving, will be very monumental in helping a prosecutor succeed in this case against him. With that being said, as the prosecutor, with that being approved, I will be able to hammer home his prior past DUI conviction along with the current case that is going on now, which would put things very much in my favor. The defense will have a hard time defending against his prior criminal incidents and this new one. Now, I do want to point out this, that under most jurisdictions within the United States of America, one of the basic rules of criminal law in most jurisdictions is that, a jury cannot convict the defendant because they think he or she is a bad person. The state's attorney, aka the prosecutor, cannot introduce evidence of other crimes unless it is approved by the judge. It's just the rule that I just showed you a few times in this video and one I went over in my previous video. The defendant may have committed simply to show that they have a propensity to commit the crime for which they are on trial. To put it in a simple term, a jury cannot convict the defendant based on simply alone character evidence. Now, there may be some debate to this in certain other trials. Like I said, there's a fine line between what's legal and what's not legal and what to be considered in a courtroom is evidence. Like I said, this is where the judge comes into play and what he or she allows in the trial as the role of the judge, and it is the prosecutor to go along with what is, approved in that matter. However, it is possible for a prosecutor to introduce other crimes as evidence for the purpose of proving a defendant's motive or intent to commit the charged crime that they are currently facing in this situation. And that's exactly what I would do as a prosecutor, and I do think it has a high chance of getting approved by a judge to be admitted as evidence in this case. But I do also want to point out, you do want to be careful when you use these previous incidents, because there has been some cases where someone can win an appeal if they were to appeal the conviction. You know, if you were successful in trial in pinning the charges against them and getting them to suffer the consequences that you desire. But in most cases, that doesn't happen. It can happen, though, if you do it improperly. That's why I said this is a strong example of how it could be used in the favor of a prosecutor to get what they desired. But also, if it is done incorrectly, you could mess up the case, and they could win an appeal because of it and get a new trial or get their case thrown out altogether. Now that I've introduced to you the facts of the case and a bit of background on Tiger Woods' prior criminal history and also just who he is as an individual, it's time for me to now dive into the case and how exactly I would go about prosecuting him. And as I mentioned earlier in this video, definitely adding on his previous criminal history is going to be a big bonus for the prosecution, and also as well going after his character is going to be a big important part of the case as well. And one of the strategies so I want to start with the statute, not just the story. I want to start with the statute. So as I had presented to you earlier, the Florida statute that he would be getting prosecuted under. Now, since I'm starting off by structuring the case around the Florida statute for driving under the influence, I really do think this case does meet a possible conviction, specifically under the second conviction, imprisonment for not more than 9 months, and if there was a minor vehicle imprisonment for not more than 12 months. If a second conviction within 5 years of prior conviction, mandatory imprisonment for at least 10 days, at least 40 hours of confinement must be consecutive. Their conviction is within 10 years of a prior conviction. So this is the big one. Ooh, this is a big one. So if you remember, his conviction where he did plead guilty in 2017 was 9 years ago. That means we would be able to go under the third conviction. If the conviction is within 10 years of a prior conviction, mandatory imprisonment at least 30 days and at least 48 hours of confinement must be consecutive. If the third conviction is more than 2 years prior to conviction, imprisonment for not more than 12 months. So this would be within that 10-year time period. So he could be facing some serious consequences if this case is prosecuted correctly. Fortunately, because of his prior conviction in 2017, I do think the prosecution, if allowed to bring in his previous criminal offenses, which more than likely they will be allowed to do, this is pretty much a strong case for the prosecution to win. The defense would have to be very strong. If they can't, which more than likely they won't be able to prevent his prior criminal history coming in, they're going to have a really hard time defending him. Like I said, they could use the strategy of making him look like a good moral character who's just down on hard times, but that will only get you so far, especially because since he is a celebrity who is in the public light, he has had a long history of being in the courtrooms, not just for criminal things, but also civil things as well. They can make him look like a horrible, bad Hollywood career sportist who just thinks they can be reckless with the law and put himself and other people in danger and make it seem as if he's just this horrible person who needs to be punished. And that's exactly what, if I was a prosecutor, I would do. Not only target that statute and apply it to his situation, but I would also go heavy in bringing in his prior criminal history and other things to make him not only look morally unjust, but under the eyes of the law, specifically with him breaking the law and applying it to that statute, shows similar to his case in 2017, exactly what he did now, and how he has not changed at all, and how he is a threat to himself and other people. And this case is a really good case for a prosecutor to have. Now, to finish things off and give it a concise conclusion, as a prosecutor, I would probably go under either the second or the third conviction, and also I would maybe impound his vehicle and have his license suspended. I do think the prosecution is making a smart move by trying to subpoena his medical records and specifically his medication, which as well can be used as strong evidence. And also as well, you can bring up the crashing involving property damage or even personal injury. I do want to point out that while in his accidents he hasn't hurt anyone else, he has ran into things which may be considered public property, and this would also be a strong case to make him seem as if he's a repeat DUI offender, and this would really make it easy for prosecution to come in and give him all sorts of penalties that he would have to comply with. Like I said, this is a case that somewhat can go either way because he did make some smart moves by not taking the urinary test, but at the same time it was enough for police to arrest him based off his breathalyzer results and his appearance that you can clearly see in his mugshot. So if I'm giving my personal opinion, and again, this is not legal advice, I would say this is really one of those 55-45 cases where if the prosecution make the right move, which I think they are definitely making in the right direction, they can play with this case and do many things that they want to do with. They have a lot of cards in their hand, and frankly, the defense doesn't have a strong number of cards in their hand that they can play outside of making it seem like he's a good guy who's just down on hard times, the family man strategy, but the prosecution can make him seem like he's a Hollywood narcissist who's doing what he want to do and he needs to be punished. So let me know what you guys think in the comments, and also like, subscribe, and share if you made it this far. Let's have a debate in the comments and let's see what y'all think about this.